What's up, everybody? Welcome back to another episode of The Lawyer You Know. And today we got Karen Reed, we got Turtleboy, we got phones, we got the Commonwealth, everybody here back. We are still not done, even on the criminal side, as the Commonwealth refuses to give Karen Reed back her phones. Why do they still need her phones? I thought a grand jury decided not to indict. I thought she was acquitted, not once, but maybe even twice of the most serious crimes in America. Why do they still have her phones? Why do they still want to search through her phones? And what if they find something else completely irrelevant to any of the charges we've heard about or talked about so far? We're going to go through the motion. I'm going to bring my dad on. We're going to talk about whether or not this is normal, whether these facts happen in lots of cases, even after somebody's acquitted, or if this is once again something very unusual happening in Massachusetts. Let's get to it. Welcome back, Dad. So you have read the motion and looked at the factual scenario that we're dealing with here, and we're going to read the motion together with the people. But just as a set of facts, right, as this fact pattern continues to grow, and now you've read the fact that Karen Reed has to have a lawyer involved in Turtleboy's criminal case because she's trying to get her phone back. There was a motion granted saying she could have her car and her phones back. They gave her car back, not her phones. Is this set of circumstances and facts normal after somebody's acquitted, after somebody's been investigated and they've gone to the grand jury as a prosecutor and the grand jury decided not to indict? Is this a normal set of facts, or is this once again something abnormal happening in Massachusetts?
Abnormal in Massachusetts. It just looks like someone is trying to gain revenge. There's no real reason not to give her phones back. Uh, they've had them for over a year. I think, if I remember right, in the facts of the case, I think they got them in sometime in 24, and they had all the time in the world to examine them for all the digital data on them. Why not give them back unless you're really trying to punish her? Plus, they took it to a grand jury, and a grand jury would not indict her for the witness intimidation. So give her the phones back. I mean, you lost the case. Admit it, roll on.
And that's the thing, is like they took the biggest swing you could ever take twice, not once, but twice, and they lost. And it's over. And as a prosecutor, sometimes you just have to realize it's over. Move on when it comes to her. If you want to go after Turtleboy and you think you have a good case against him, which it seems like it's falling apart. I talked to Bettero about it a little bit when he was on last time. Completely seems like that case is falling apart, but whatever. There's an open criminal case there. If you want to have evidence and keep it collected and go through it and build a case, whatever. It's like Karen Reed. You took the biggest swings twice and missed. Then you tried to indict her with Turtleboy in the grand jury and missed. One of the more concerning things to me is while they have this phone, if they continue to search it, let's say they find something else criminal that has nothing to do with John O'Keefe's death, that has nothing to do with the witness intimidation or any of Turtleboy's cases that are open right now. Let's say maybe she's talking about a different witness. Maybe she's, telling somebody to lie on the stand in her trial or something like that. If they were to search these phones and find something completely different on a fishing expedition, would they be able to use that potentially?
Yes. I mean, if the court allows them to do the digital examination they want to do, and if they did find something criminal other than what they were looking for, they can use it.
And that's kind of the difficult part here. That's why when you have these unreasonable searches or people's rights are violated or people say, sure, you can go ahead and search for marijuana. Like cop says, I smell marijuana. You're like, I don't have marijuana in my car. Go ahead, search my car. And they find a firearm or they find cocaine or they find something else. It's like, that's still criminal. You're still getting arrested. You're still going to jail. And that's why you have to make sure your rights are protected, even if you did nothing wrong, because they might find something else that you don't even know is there. Could be somebody else's, whatever it may be. You could be in somebody else's car. Regardless, let's take a look at this motion together, break down the important parts here that stick out to us. So this is first off, Commonwealth v. Aiden Timothy Carney. Turtleboy. This is not in Karen Reed's case because Karen Reed's case is donezo or never existed if it comes to the witness intimidation. Miss Reed's memorandum in opposition to the Commonwealth's motion for examination of digital material seized from Karen Reed pursuant to the search warrant issued on January 22nd, 24.
Yeah, let's take the unusual aspect of this too. They seize it. They have a search warrant. They've got it in their possession. They got it in January 22nd, 2024. Did nothing with it. And apparently they've got to come back now and go through the digital data. It's inconceivable to me that, again, you have this murder trial, I mean, this M trial. You had an M trial that happened and they didn't look at the digital data on their phone. That doesn't make a lot of sense. That's sloppy police work.
To me, it's just par for the course. But here's the point: whenever it comes with her first trial or second trial, the grand jury attempt, all of that's done and in the past. They had the proper legal opportunity to review this evidence that was seized, apparently legally, back in 2024. There is absolutely and if I was a judge on this case, I would look no further than Brian Walsh and the King case and all these other cases where this DA's office sits on evidence, doesn't review it appropriately, doesn't ask law enforcement to review it appropriately, doesn't follow the rules of discovery, doesn't let defendants know what's going on, doesn't turn over discovery appropriately. They sit on their hands all the time. It cannot be allowed to continue. And this would be like a parent who is an enabler to their child who continues to make mistakes. If you're the judge, you have to hold them responsible, that you have to hold them to account, hold them to the rules, like another motion we read the other day. Rules without teeth are worthless. And so if you're going to let them do things like this and then investigate it after the trial's over, after the grand jury didn't indict, what is the point of allowing them to get it in 2024? It makes no sense. That's when you're legally supposed to look through the evidence, download the data, and see if you can find anything that's going to help your prosecution. Not now.
Again, all it is vengeance. That's all. They're trying to find something to hang her with because they lost the big one.
Yeah, and I usually say this is going to be Exhibit A to something, but there's so many exhibits at this point to the 1983 action. But they are filing lawsuits against all sorts of people, including law enforcement, and this might be Exhibit Z for them as just another thing they're trying to do to hurt Karen Read, make her life more difficult, make her pay lawyers to, when there was already a court order. Let's read the motion here because we're jumping ahead. But it says in the motion, there's a court order, you got to give the phones back. So let's get to this. Now comes Karen Read, a third party to this matter, and respectfully request that this honorable court deny the Commonwealth's motion for examination of digital material seized from Karen Read pursuant to the search warrant issued on January 22nd, 24. The Commonwealth has no probable cause whatsoever to believe there is any new evidence of criminal activity contained within Ms. Read's cell phones because any information that the Commonwealth might hope to glean from the requested records is duplicative of the information already contained in Mr. Carney's cellular telephone records, which have been in the Commonwealth's possession since the start of this case. The Commonwealth has failed to allege particularized facts that any information contained in Ms. Read's cellular records beyond the information that is already in the Commonwealth's possession is relevant in any way. This court should return Ms. Read's personal property immediately. So talk about also the fact that if they're really trying to cook the case up against Aiden Carney, and they're trying to use that as a reason to keep Karen Read's phone, they already have Aiden Carney's phone. So any of the text messages Karen Read sent Aiden Carney would be on Aiden Carney's phone.
Well, honestly, that's not an argument that's really swaying to me because they would have a right to compare what's on her phone to Karen's phone if they had the right probable cause to go ahead and look at her data. Yeah. So, he could have deleted something. Yeah. It's okay for them to go to, a secondary source to back up the information.
But they should have already done that by now.
Yes, they should have.
Miss Read's phone was searched by the Massachusetts State Police pursuant to a search warrant February 2nd, 22. 4 months later, January 9th, 22, Miss Read was arrested a second time for the same incident. On January 24th, 24, Lieutenant John Fanning seized 2 more of Read's cell phones pursuant to a seizure warrant issued on the basis of witness intimidation allegedly perpetrated by Miss Read. On March 27, 24, unbeknownst to Miss Read, the Commonwealth convened a grand jury to determine whether a true bill should issue requiring Miss Read to stand trial for numerous counts conspiring with Mr. Carney to engage in witness intimidation and or harassment against Brian Albert, Colin Albert, Chris Albert, Jen McCabe, Matt McCabe, and former trooper Michael Proctor. On the very same day, March 27th, the grand jury concluded there was insufficient evidence to find probable cause that Miss Read committed the acts of intimidating or harassing the witness, officially rejecting the Commonwealth's allegations. So let me ask you this question. Somebody with vast experience, you said you've never really seen a motion or facts like this before. How common is it for a Commonwealth to charge and try somebody for killing someone and lose, to try and indict them on any crime and get no bill? The same person. How unusual is that?
Well, first off, and I've done probably 100 or so grand juries. I've never lost a case in a grand jury. And it's very rare for a prosecutor to lose a case in a grand jury because number one, grand jurors think that, you're the end all and be all as the assistant U.S. attorney or the assistant state attorney in the grand jury room. There's no defense lawyer there presenting the other side of the case. So you present the grand jury one side of the case and you still lose. That really is really odd. And so I got to tell you, at that point, they should have just given up if they couldn't convince a grand jury in that setting, that there was somebody to indict. And the burden is probable cause. So they couldn't even establish probable cause for that grand jury to indict somebody.
which is similar to what you need for a warrant. So it's like if the grand
Right.
jury didn't think you had probable cause for that crime, why are you keeping evidence that you're saying you have probable cause of? And obviously some judge agreed somewhere to sign the warrant, but in reality, so you just said how unusual it is to lose a grand jury, but that's on top of also losing the murder trial. Like that doesn't usually happen. The percentages of losses on a trial like that, combined with the percentages of losses in the grand jury, I mean, we're in like the fraction of a percent of how bad this is for the DA.
Fraction of a fraction.
Yeah.
It's that small.
On July 1st, 24, a mistrial was declared after the jury deadlocked. Ms. Reed did not learn about the grand jury's rejection of her alleged involvement in witness intimidation until a notice of discovery produced by the Commonwealth on October 10th, 24, approximately 6 months later. On April 22nd, 25, 1 year after the start of her first M trial, Ms. Reed was retried for second-degree M, manslaughter, and leaving the scene. On June 18th, 25, the 3.5-year saga came to a just end when the jury acquitted Miss Reed of all charges related to John O'Keefe's death. After her acquittal, the Commonwealth remained in possession of Miss Reed's personal property. On July 25, Miss Reed filed 2 motions for the return of her property, one for her Lexus and cell phone seized on January 22, a second for the 2 cell phones seized on January 24. Miss Reed's motion to return her vehicle and cell phone seized on January 22 was granted without an objection on August 11th, 25. Rather than complying with Miss Reed's motion to return her 2 cell phones that were seized on January 24, however, the Commonwealth submitted the instant motion for examination of Miss Reed's latter 2 cell phones. One thing I did want to ask is, what's the scenario when somebody doesn't get indicted in a grand jury? When are they supposed to find out? Do they ever find out? Do you have to tell them? How does it work from a prosecutor's side?
You don't have to tell them. You don't have to tell them of the investigation. You don't have to tell them that it's no true bill is what happens when the grand jury doesn't indict. You don't have to tell them about the no true bill. And a lot of times they never find out that there was ever an investigation or whatever happened to the investigation.
Okay, argument, legal landscape and evidentiary standard. In Massachusetts, like many other states. So by the way, they had it granted already that they had to turn over her Lexus and her other cell phone, and they turned it over, and they didn't object to that. But this one they're fighting. Okay, that's the difference between the 2 motions they filed. In Massachusetts, like many other states, prosecutors may, in certain circumstances, present identical evidence to a second grand jury after failing to obtain an indictment from a first grand jury. So that's another question. How often does that happen? Why is it not double jeopardy? People always ask that as well to try to understand, like, what does it actually mean to be put in jeopardy? So why don't you explain a little bit of that?
Well, first off, it's very, very rare to represent the same evidence. Now, I've seen cases where they have found new evidence. So they present it to the grand jury with the old evidence plus the additional new evidence, which they think could change the grand jury's mind. I've seen that. But the same evidence to 2 separate grand juries, actually, I've never seen that because, frankly, prosecutors should be busy and they should have other things to do than to try to keep going back to the grand jury with the same evidence in the same case. Again, they should move on to other crimes. So this is very unusual. Double jeopardy doesn't apply because jeopardy only applies if you are in jeopardy. In other words, you go to a trial with a jury, and if you lose that trial, you can go to prison. That's jeopardy. In this case, the fact that a grand jury indicts you, again, grand jury is a secret. You don't even know you're under investigation. So there is no jeopardy for a grand jury indictment because the indictment alone won't send you to prison. But there is jeopardy in a regular jury trial with what we call a petit jury, where you actually have the defense and the prosecution there, and you're convicted and you go to prison. That's jeopardy. Again, this is not jeopardy because this indictment won't send you to prison.
Right. And that's when jeopardy attaches. You'll hear lawyers use that terminology. Jeopardy attaches once the jury's sworn in. And if they convict you, you're going to prison. That's not what happens in a grand jury proceeding. However, this power is not absolute. The purpose of the indictment by a grand jury is to shield the innocent against hasty, malicious, and oppressive public prosecutions. You think maybe they should have highlighted that line here? Because that's what it's certainly what it feels like here. And if they were really going to go after witness, imagine this. They go second time, same facts to a second grand jury on witness intimidation charges where the witnesses are cops and the person that intimidated the witness has been found not guilty. And the jury has come out and said after they find her, they think that she is factually innocent. Imagine continuing a second time after that person. It just makes literally no sense at this point.
There's only one logical explanation for it.
Right. I can understand if somebody died and you're going after them again for taking their life and you go to a second grand jury because you're really trying to get justice for that. That's not what this is. Come on.
No.
Repeated submit. What?
No, I'm just going to say no.
Yeah.
You're right. Go ahead.
Repeated submissions of identical evidence to successive grand juries, especially in light of harassing, malicious, and biased prosecution, poses a limitation on the prosecution's ability to resubmit evidence to a new grand jury. For example, when a governmental body has no legitimate or reasonable purpose for pursuing an indictment by grand jury after repeated attempts, the court may inquire into the prosecution's stated purpose and prevent resubmission, which I think should apply here. Some courts have indicated that even in the absence of statutory limitations, the power to resubmit is not boundless nor immune from judicial control. In the Commonwealth versus McCravey, the Massachusetts Supreme Judicial Court stated it would bear consideration whether submission of the same evidence to multiple grand juries would be inconsistent with the purpose of grand juries to shield the innocent against hasty, malicious, and oppressive public prosecutions. While it is the general rule that a court should not inquire into the adequacy or competency of the evidence upon which an indictment is based, when it appears that the integrity of the grand jury process has been impaired, a defendant may attack the validity of the indictment by way of motion to dismiss. And again, although some of this may be outside the box, it may not be normal, that's exactly what this case is. That's exactly what we have here.
Well, that's why grand jurors, when a grand jury is impaneled, there is a judge assigned to supervise the operation of the grand jury. And the whole purpose of that judge is to make sure that it operates within the law. They're right that judges don't go behind grand jury decisions. That's for the grand jury to make their own decision, and they're supposed to be independent. But it's the process that judges are supposed to protect. And in this case, they're challenging the process. And I think it's absolutely correct. I don't know what's going to happen in the case, but absolutely, I think a judge should definitely do an inquiry here to find out what the how the process was and why they're actually doing what they're doing.
Right. And if their answer is, we just waited to look at her cell phone evidence until after her 2 trials, it's not a good enough answer.
No, and I think they have some case law in here that would indicate that that's not a good answer.
Right. Although no indictment has been secured in this case, the process of seeking the same bears on the analysis similarly. Improperly seeking evidence under the guise of later seeking an indictment impairs the process from the outset, which the courts are loath to sanction. The pertinent witness intimidation statute reads as follows. Whoever willfully, either directly or indirectly, threatens, attempts, or causes physical, emotional, or economic injury or property damage to, conveys a gift, offers or a promise of anything of value to, or misleads, intimidates, or harasses another person who is a witness or potential witness, a person who is or was aware of the intimidation, records, documents, or objects that relate to a violation of the criminal law or a violation of the conditions of probation, parole, bail, or other court order, judge, juror, grand juror, attorney, victim, witness, advocate, police officer, correction officer, federal agent, investigator, clerk, court officer, court reporter, court interpreter, probation officer, or parole officer. Person who is or was attending, or a person who had made known an intention of attending a proceeding described in this section, or family member of a person described in this section with the intent to, or with reckless disregard for the fact that it may, I have some comments on this in a second, impede, obstruct, delay, prevent, or otherwise interfere with a criminal investigation at any stage, a grand jury proceeding, a dangerousness hearing, a motion hearing, a trial, or other criminal proceeding of any type, or a parole hearing, parole violation proceeding, or probation violation proceeding, or an administrative hearing, or a probate or family court proceeding, juvenile proceeding, housing proceeding, land proceeding, clerk hearing, court-ordered mediation, or any other civil proceeding of any type, or punish, harm, or otherwise retaliate against any such person described in this section for such person or such person's family members. Participation in any of the proceedings described in this section shall be punished. That's an incredibly vague and wide-ranging witness intimidation statute, especially to say willful, either directly or indirectly. So if you indirectly threaten, attempt, or just cause emotional injury, indirectly causing emotional distress to somebody that's a witness or a family member seems awful wide ranging to me.
It's not unusual, though, honestly. I mean,
Feels wild.
they said a lot of words here that they could have condensed.
Right.
Because, for instance, when they went through all those proceedings, all they had to say is any official proceeding. That's the way
Yeah.
the federal government
Yeah.
intimidation statute reads. Any official proceeding, rather than going through all that mumbo jumbo that they went through.
Yeah.
But the indirect is if you don't have to directly do it, but you can cause somebody else to do it. That's always been the law. And if we go on, we'll see that in this case, that's what they're saying. They're not saying that she directly did it, but they're
Right.
alleging that she indirectly did it by encouraging Turtleboy to do
Right.
it.
Article 14 of the Massachusetts Constitution requires that all searches and seizures be reasonable. Searches and seizures conducted outside the scope of a valid warrant are presumed to be unreasonable and therefore unconstitutional. To be reasonable in the constitutional sense, a search conducted pursuant to a warrant must be supported by probable cause. To comport with the constitutional protections, an affidavit in support of a search warrant must demonstrate probable cause to believe, one, that a particularly described offense has been, is being, or is about to be committed, and two, that the search will produce evidence of such offense or will aid in the apprehension of a person who the applicant has probable cause to believe has committed, is committing, or is about to commit such offense. In addition, a cell phone search must be timely. The state must act within a reasonable period after the seizure, else the seized material must be excluded. The Commonwealth has no legitimate purpose for its motion and is simply attempting to continue its persecution of Karen Read. The Commonwealth lacks the necessary probable cause to support their requested search warrant because the requested search will not produce evidence of the alleged offense, nor will it aid in the apprehension of an alleged perpetrator. The basis of the Commonwealth's inquiry into Miss Read for the offense of witness intimidation is a groundless allegation of indirect witness intimidation. This is evidenced by Trooper Tully's supporting affidavit, which only describes conclusory allegations of witness intimidation as occurring through Miss Read's communications with Mr. Carney. It is murky whether he believes those communications were direct or indirect, and he has no stated foundation that any communication actually are in furtherance of witness intimidation. Rather, Tully spends nearly the entire affidavit describing Carney's alleged conduct, not Miss Read's. The communications presented by Trooper Tully between Mr. Kearney and Miss Read actually show the opposite of the witness intimidation. She is clear that information should not be used or disclosed or disseminated. There is absolutely no evidence of Miss Read ever urging or even suggesting to Mr. Carney that any witness be contacted, approached, or even discussed in Mr. Carney's reporting. Further, the Commonwealth lacks probable cause to search Miss Read's cell phones in accordance with either of the standards of the second prong of the Eastbrook test because they are already in possession of the information pertinent to the prospective allegations. Paragraph 7 through 41 of Trooper Tully's affidavit have nothing whatsoever to do with Miss Read and only concern Mr. Carney. Tully's affidavit perfectly encapsulates the reason why the search warrant is unnecessary and why the Commonwealth lacks probable cause to search Miss Read's cell phones. Paragraph 44 reads, Natalie described the arrangement as follows. Karen would send Natalie a message on Signal intended for Carney. Natalie would copy and paste the message, photo, video, document into a text message to Carney. On several occasions, Natalie would take a screenshot of the Signal message from Karen and send Carney the screenshot. Natalie stated she would send information to 2 phone numbers used by Carney. Because the Commonwealth's groundless allegation seeks to suggest that Miss Read communicated some unknown things to Mr. Carney and he therefore engaged in witness intimidation, the only relevant communications would be those actually received by Carney. So what do you think about that? It doesn't matter if she sent them to somebody else or what's on Karen Read's phone. It matters what's on Carney's phone and what he actually saw and heard and did because it's indirectly encouraging him to commit witness intimidation.
To me, that's not a really strong argument either. Because let's say she talked to somebody else and said, hey, I told Carney to go ahead and punch this witness in the nose,
Yeah.
that would be relevant. It's her statement saying that she made an admission saying that she had told Carney something. So the fact that she talked to somebody else and would have said something incriminating, that can be used against her and it can be good evidence.
And he can still deny it and say, I never heard that. She never told me
Right,
that. But this
right.
would be actual record, objective evidence the prosecution could use to say, and the jury would decide whether or not they believe she actually told him to or not. For example, if a hypothetical communication was written by Miss Reed on her phone but not passed along to Mr. Carney, that cannot possibly be an example of witness intimidation, as the Commonwealth has not and does not allege that Miss Reed actually carried out any intimidation herself. So you explain how that's not actually true. If she sent it to somebody else and said, tell Aiden Carney this, even if it didn't get to Aiden Carney's phone, it doesn't mean that person didn't tell Aiden Carney.
Right, right.
And the Commonwealth is already in possession of all communications received by Mr. Carney. The Commonwealth has searched the entirety of his phone. It is impossible that a search of Miss Reed's phone would produce any evidence that is not already in the Commonwealth's possession.
I don't know how they could say that.
Yeah,
You
I
know,
agree with that.
so
The Commonwealth has other side of the has the other side of the handshake if such exists. Therefore, the Commonwealth lacks probable cause to search Miss Reed's phone, and the Commonwealth's motion should be denied. I think the timeliness is the better argument personally, and the fact that this is clearly done for vengeance and they already had their
right.
opportunity. That's the best argument.
Right, and the general probable cause. Do they actually have they actually stated probable cause that they would find evidence on the phone? I really, if you believe the way they've interpreted Tully's affidavit, then it looks like Tully didn't say that there's anything on Karen Reed's phone that was evidence. Now, yes, if they said, yes, there is evidence on the phone, we believe there's evidence, we have probable cause to believe that, then yes, they can look at the phone. Again, the timeliness argument would still come in. But first step is they've got to say there's actually something on this phone they can use. I haven't seen that yet. And if you believe the way they've interpreted Tully's affidavit, it's not there.
Right. By the way, everybody take a second, hit the like button, make sure you're subscribed, hit the subscribe button, make sure you do all that before every video, but I usually remember and I forgot till now. The final paragraphs of Trooper Tully's affidavit expose what this motion and the Commonwealth's overall plan truly is: an overbroad and persecutory fishing expedition intended to punish and harass Miss Reed. I think defense lawyers say this type of stuff a lot. They don't usually have as much evidence as they have in this case that could actually be the truth. Would you agree with
Which
that?
is why I think in this case there should be judicial intervention. I do believe that the judge should take a look at this and have to and ask the questions of the prosecutors. Justify this to me. Justify why you're doing this and justify why you did all these other things that are listed in this motion that on their face it looks like it's strictly persecution.
Like, what do you think you're going to find? Where do you think you're going to find it? Why didn't you already search this? Why didn't you use it in the grand jury proceeding last time? They already said no to whatever you did present. Like, those are the types of questions the judge should ask the
All right.
prosecutor.
But keep in mind, the arguments about Tully's affidavit and whether Tully's affidavit had probable cause. If the judge finds that Tully's affidavit had probable cause, the prosecution cannot correct that
Right.
lack of probable cause at this hearing. They can't add stuff to Tully's affidavit at this hearing because that affidavit was the affidavit when they issued the search warrant, and that's what that judge went on. And if that affidavit is insufficient, even though we have some case law that a good faith affidavit is still good, even though it may have some deficiencies. If the judge finds that that affidavit does not comply with the law, then that's over. The prosecution cannot add facts at this hearing that's going to justify the search.
In paragraphs 96, 97, and 100, Trooper Tully states that a reason for searching Miss Reed's cell phones that the MSP needs to examine Miss Reed's location data and application usage, which is literally everything on the phone, to determine whether the phones actually belong to her. This thinly veiled excuse to rifle through the entirety of two of Miss Reed's cell phones, including all of her personal information, is absurd. And then the other thing they also have in this case is the misuse of evidence and looking for nudes on her phone and all the stuff that they already did prior. That just is not a good look. This whole case is poison for the prosecutor's office and for law enforcement, which is why it's just embarrassing at this point that they continue down this road.
And as you read on, that's a good argument. The fact that they're claiming that they don't know if it's her phone or not, that is an absurd argument.
Trooper Tully argued, expecting this court to take him seriously, that the police and district attorney need to review the entire contents of Miss Reed's phone, including whatever personal, private, confidential information lies within, to prove that the cell phone seized from Miss Reed's possession in Miss Reed's own home are in fact hers. The same cell phones that Miss Reed's counsel have demanded to be returned to her as the rightful possessor. It's like, yeah, you already have that answer. Come on. That the Commonwealth would actually present such an argument as justification to root through her personal data speaks volumes about the true intentions of the prosecutor and investigator behind its motion. And again, all of this kind of is giving you more ammunition for the 1983 action. The Commonwealth's request is untimely, and therefore the information sought cannot be admitted. As we learned extremely recently in the Commonwealth v. Diaz, the Commonwealth may not seize a cell phone and indefinitely deprive its owner of their possessory interest before seeking a search warrant. That's something we haven't even talked about yet, is like, you have the right to possess your own property, right? I mean,
Right.
there are so many rights involved here we're talking about that are getting stepped on. And one of them is we have the right to, if we purchase and own something, it is ours. They can only take it from us under very specific and certain circumstances, and this shouldn't be one.
And this is a constitutional argument. Fourth Amendment, unreasonable search and seizure. That's why they can't take something from you unreasonably, and they have to have a reason, and it has to be a legal, constitutional reason.
The police may retain an item seized without a warrant for the relatively short period of time needed to obtain a search warrant, but must release the item if a warrant is not obtained within that period. If the police fail to obtain a search warrant within a reasonable time, the seizure, even if it was reasonable at its inception because it was based on probable cause, may become unreasonable as a result of its duration. They cited a case that said when officers fail to seek a search warrant, at some point, the delay becomes unreasonable and is actionable under the Fourth Amendment. The Commonwealth bears the burden of demonstrating that the delay was unreasonable. That's the case they cite. The Diaz court held that individuals have a critical possessory interest in their cell phone. We first note that the defendant had a material possessory interest in his cell phone. Many who own a cell phone, in effect, keep on their person a digital record of nearly every aspect of their lives. We all know this today. This is not going to be a surprise to this judge.
Even I do.
Yeah, exactly.
Even me.
The Massachusetts Appeals Court less than 1 month ago held that a delay of 123 days between the seizure of a suspect's cell phone and the first time the Commonwealth seeks a warrant to search it is unreasonable. The judge ultimately concluded, based on these findings, that there is no legal precedent for finding a delay of 123 days to be reasonable, even with a compelling government interest. That's the point. So January of 24, like, to me, this is kind of an easy decision, in my opinion. That conclusion is, to date, correct under Massachusetts law. The court further opined that our courts have recognized that some delay in obtaining a search warrant may be reasonable, whereas here, the governmental interest in the seized item is critical. But there is no Massachusetts precedent upholding a reasonable anything remotely approaching the 123-day delay in the present case. Here, the Massachusetts State Police seized Miss Reed's cell phone on January 24, 24, did not seek a warrant to search its contents until August 28, 25. This is a gap of 582 days, nearly 5 times longer than 123 days that the Diaz court held to be unreasonably long. The law is perfectly clear. The Commonwealth's request is well beyond untimely, and therefore the evidence sought must be suppressed. What do you think about that argument?
That's a good argument. And I tell you, again, this is a case that has all sorts of bizarre stuff, but I've never had a situation where they seized a cell phone, and I've been in hundreds of cell phone seizures where they did look at the data right away. It just doesn't make sense. Why do you seize a cell phone if you're not going to look at the data? Why'd they just put it on a shelf somewhere for 582 days and then decide now to seize it? If I was a judge, that's the question I'd want to ask.
Well, I mean, if you remember back to some of the hearings we watched with Walsh and King, that none of that makes any sense. It's like, Lally, what's your process if you ask law enforcement for documents or for evidence and they don't give it to you? Nothing. You don't follow up. You don't give them 5 days. You don't ask a supervisor. You do nothing. So you just continue litigating the case without the evidence. You don't even have the evidence, let alone turning it over to the defense. None of it
never happened. That never happened in my cases.
Never once.
I can tell you.
How do you litigate a case like that? How would you possibly litigate a case like that? I don't understand.
And I got to tell you that law enforcement normally, again, there's nothing normal about law enforcement in the Karen Reed case. But normally law enforcement is very responsive because they want a conviction. So if a prosecutor says, I need this evidence, I need this data, I need this analysis, they give it to them because they want to win the case. And they don't want to alienate the prosecutor, because the prosecutor you have in this case, he's going to be a prosecutor you're going to have in another case. And if he has a bad impression of you, he's going to deal with you that way.
Yeah, nobody seems to care in this case about reputational harm, or, it's always like your career is not one case. Well, if it goes this poorly, sometimes your career can be one case. And when you do something unethical as a lawyer, like that could be everything. Your reputation is literally everything, and they just don't seem to care.
Well,
And that's the problem.
and you know what else too? Again, about reputation. In the U.S. Attorney's Office, and even when I was in the state attorney's office, if you file a complaint about an officer, that officer is not responding to you and giving you evidence or doing a proper investigation, that goes into that officer's file, and it could affect his promotions. It could affect his future in the agency. Apparently, that doesn't happen in Massachusetts. Apparently, you have to really be bad before you have any effect on your career.
Frankly, you might get a promotion if you withhold
I
evidence in
know.
Karen Reed's case. I mean, and that's the point, is like, we could joke all we want, but this is how it's not supposed to be. And you're seeing how when things are left unchecked, it just, like, a lie left unchecked becomes the truth. Well, complete incompetence throughout the litigation of a case and prosecution of a case, if you leave it unchecked, it's injustice. Like that's what happens, is people's rights are violated. There's no shame in their game. No shame in their game. They are willing to say, well, we want to make sure it's her phone, judge, so we've got to look through everything. And then once again, like we said, if they're confirming it's her phone and they find something that they can try to argue as criminal activity, bada bang, here we are. And that's the problem. That's what we need to avoid. That's where a judge must step in. If the prosecutor's not going to step in and law enforcement's not going to step in, a judge must step in.
It also sounds to me like they're admitting it's her phones. So
Right.
there isn't any issue whether it's her phone or not.
They didn't
So
technically say it's her phone, but they did
yeah,
everything but say it's her phone.
yeah. So have a hearing. Is it her phone? Yes, judge, it is her phone. Okay, then you don't need this. Then you don't need the search warrant anymore. You don't need the digital data.
And why would confirming it's her phone give them probable cause if they don't have anything else that they need for the witness intimidation? Doesn't
I
make
don't
sense.
know. Yeah.
And they could have just said we stipulated it's her phone, but they didn't for whatever reason. All right, the
Well,
conclusion.
I think they filed a motion. I think they filed a motion though, asking for her phones back, and they included these phones.
Correct. It's true. Miss Reed's phones were seized on January 24th of 24. No action was taken on the allegations of witness intimidation until a year and a half later, when the Commonwealth penned this motion. Conveniently, the motion only came to fruition after Miss Reed's requested that her personal property be returned. Only then did the special prosecutor indicate an intention to rummage through her cell phones in the first instance. The Commonwealth cannot claim that they were merely waiting for Miss Reed's trial to conclude before pursuing this action, because they attempted to indict her before a grand jury while her first trial was pending. Talk about the timing. That's really interesting timing, and that's great evidence for Karen Reed that this timeline made no sense. It's not true.
Right. So, and I would guess the special prosecutor, which I'm assuming is the appointed defense lawyer that they had as a prosecutor. I guess that's who they're referring to as the special. It's funny
I
that
don't know. He's not handling this case.
No, but when they refer to the special prosecutor, is that who they're referring to? Because
No.
if he knew that there was a
No.
grand jury going on while the trial was going on, that's an interesting fact.
Well, hold on. Are they talking about Hank Brennan?
Yes.
No, that's not there. The special prosecutor right now is intending to rummage through her cell phones. Hank Brennan's gone. So it's the special prosecutor on this case. I don't know if that's Cosgrove or who it is, because Cosgrove just got booted from one of Aiden Carney's cases. It's a mess. Mark Betterow said basically the entire DA's office is completely conflicted off this case because victims and witnesses and all these people are suing them and suing law enforcement and suing special prosecutors. It's crazy. It's absolutely crazy. For the above reasons and for those argued by defense counsel at the hearing of this motion, Ms. Reed respectfully requests that this honorable court deny the Commonwealth's motion and order Ms. Reed's personal property be returned forthwith. Yeah, Hank Brennan, he might be the only one that's not conflicted off at this point, but I think he wants nothing more to do with this. I think he hopefully learned his lesson the last time around, that this isn't going to be helpful.
Yep.
So, Go ahead.
it was it was a tough loss for him, I'm sure. You could tell he had an emotional attachment to it, just like all the lawyers, frankly, in the Karen Reed case, had an emotional attachment to the case. So yeah, he wants to stay as far from it as possible. Frankly, he hopes nobody asks him about it.
Yeah, I think that this motion should be denied, and Karen Reed should get her phone back, meaning the Commonwealth's motion to search her phone should be denied. She should get her phone back. We can't allow them to continue to work like this. This is an easy decision for the judge. In the trials of Walsh and King, where they're accused of killing people, it's a more difficult decision for a judge. Like, what am I going to allow in? This incompetence and the delay and the discovery and the negligent prosecution that's happening over there. I can understand why that's a tougher give for the judge, because you really want justice for those victims. And if the evidence is overwhelming, you've got to make sure everybody's doing their job. If you can continue the trial and protect people's rights or whatever it may be, very different than where we are right here. Right here, right now in this case, justice is not allowing them to rummage through her personal items in her phone. No way.
Maybe you know the answer to this, but I think, if I heard right, there's actually a new judge because the judge who heard the trial has rotated off into another division, and there's a new judge that's hearing this stuff.
This is Aiden Carney's case, not Karen Reed's case. So it's
Oh,
not
okay.
it's not
So it's a
Canoni.
totally,
It's Aiden Carney's
oh,
judge. Yeah. And Aiden Carney's judge, I think, is I haven't like watched all the hearings and stuff, but Prof.
interesting. Yeah.
Federo, like, he's getting this person booted off the case. There's just all these problems, and it doesn't seem like the judge is as much of an impediment. I don't know anything about the judge. I don't even know the name of the judge, but the impediment that was Judge Canoni does not seem to exist in Aiden Carney's case. So yeah, completely different decision makers, completely different prosecutor, different players in this game than Karen Reed's case, but the same DA's office and the same negligence happening, so it seems. But
Well, I hope there's a hearing. I mean, I do. I hope there's an open hearing, and I would really like to see the prosecutors answer the questions, the tough questions that a judge should ask.
yeah, that'll be interesting. If there is a hearing, I'm sure the people listening to this video will send it to me and we will break it down, because this is interesting, man. Every time something happens in this case, I'm like, what? This? Seriously? This is what they're doing? Like, when they asked for the phones in the car, we were like, oh, yeah, it's a foregone conclusion. They're going to give it all back. And then, of course, stupid us, we should never assume something's going to go as it normally does. But that's all we got for this one, Dad. Thanks for joining me. I appreciate it. Appreciate your input, as I know everybody else does. Until next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.